Oh, okay. We got the mic going now for Rumble. All right, let's get the screen share going. We're going to do it through free conference call and then free conference call, Telegram. Okay, so hopefully we should have sound everywhere. Picture, at least being able to see me and screen sharing. Okay, so now we should be able to, and everything should already be recording. So let's go ahead then and get to the presentation. Okay. Whew. All right. So welcome. Technology. And as it was, I need to get to a point where I can only do get some meat this evening. I have some plans this evening. My husband and I, it's our 29th anniversary. So we want to spend some time. My husband's off for this evening. So we're going to spend the evening together. So try to get this wrapped up, still get the main points out for everyone. And but that's where we're at. So let's go ahead and get things going. Again, I'm Christine Van Pelt, State Coordinator for the Indiana Assembly. This is Monday, May the 13th, 2024. We are in session. And let's go ahead and take a moment to honor our Creator. Thank you. All right. Go ahead and jump through to the Bivens decision. This meeting is private, bearing false witness, misrepresentation, posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at today's meeting that is a member of any law enforcement agency or public agency of the federal, state, county, city, or township agencies present? Is there any response to the Bivens decision for the first time? And you can post that in the chat. It's not that you can't be here. It's just that it's nice to know up front. Don't surprise us. We are Americans and we like to be up front. And if you're interested in learning more, great. We're here for you. All right. Hearing and seeing none. I'm not seeing anything there either. Okay. Is there any response to the Bivens decision for the second time? Hearing and seeing none. Is there any response to the Bivens decision for the third and final time? Hearing and seeing none. Further, anyone who is here under false pretenses, anyone who is working for any foreign government, including the territorial United States or municipal United States, anyone who is being paid or coerced to be here must fully disclose their presence and purpose now or leave the premises. Are you now or have you ever received any money or personal support of any kind from the intelligence community? You can also comment on that. And so sometimes it's also right to note that this Bivens decision goes throughout the entire call, because many like to think that if they show up after this portion of the call, then they're not bound to answering the questions. So you're still bound if you come in afterwards of making that conscious decision. Are you or are you not? Okay. And again, many like to wait to come in later, to wait till all this other stuff, which is actually important for them to know. Disclaimer, we are engaged in practice of self-governance. Everyone here is volunteering their precious time and skill. Each one is an American with rights and prerogatives equal to your own. They're doing this work out of mutual necessity to restore the lawful American government. Demands for service, temper tantrums, and misplaced anger are inappropriate. This country does not belong to its government. This country belongs to the people who live here, and you are one of them. If you're of the living, right? All right. Assembly participation, nationality is a birthright, but assembly membership is a choice. So therefore, it is also, you will behave yourself. You don't just come in here and think you're going to take over. You're going to respect the space. And we all come together to make sure and respect that space. All right, so we have our reading for the ex parte Milligan. I've already got that recording loaded up. And really, I just want to make sure and we cut to the chase and get to that, because all the other information is in there. I have moved a few things around within. I have added some minor things. But do make sure you go ahead and still look through the presentation. I will be able to have the presentation and the free conference call link up on the Assembly the indianaassembly.org website at the top for calls, for assembly calls, and I'll have it posted within a few minutes after the call. Free conference call is one that provides a link, so it's much easier than through the webinar service where I have to wait for it to render it, and then I have to upload it before I can even post it. So, but I'll be able to do these real quick right after. Obviously, I got to take a minute to load in who all was on the call with us so we can make sure that they get recognized. And we want to make sure that we're adjourning for May 20th for the next General Assembly call and May 27th for the next Jural Assembly, 6 p.m. Central for both of those times. All right, so I'm going to go ahead and just cut right through, get here to our mission statement. That's key. We need to be reminded of what our purpose is, right? Our Indiana Assembly is dedicated to the restoration of a complete and fully operational land and soil jurisdiction, state and county court system, serving the people of Indiana, the preservation of the national trust, the enforcement of the public law, the upholding of the federal constitution owed to our state and people, the repopulation of our land and soil jurisdiction, the filling of vacated public offices, and the reclamation of our material and intellectual public and private assets. To these ends, we, the living people of Indiana, have called the eligible Indiana nationals and citizen electors to assemble and to serve as jurors and officers. And we have established the process and procedure to qualify jurors and others competent to hold state citizenship and public office. We do this peacefully and without rancor in the exercise of our unincorporated powers and capacities. All right, and you can read through these as well. These are the important documents. Some there are for you to actually complete and send email records at theindianaassembly.org, and some is for your information. Call to public office, the different offices that are available, and more details about them. These links all here about all the different committees that and deeper into about what those committees are. Reminder of your public duty. I've gone ahead now, and since this is all important document links that we're supporting with, I've moved the ex parte Milligan to here as well. So it is here. Reminder, there is a Eventbrite, I think, set up for, you're not paying, I don't think you're paying for any service through it. It's just that you're, signing up to say, yes, your plan is to go with. And then that way we can start gathering that information. And as soon as I can get the Eventbrite link, I will add that to here so you can also go there to get more information about it. And that is the countrywide trip to Faith Monument. And there's 2 video links, a short one on TikTok, a documentary further extended from Kirk Cameron about Faith Monument. Check us out on Telegram. Don't forget to make sure and also check us out on Telegram, not just making sure you're with the American States Assembly, which that's great. And of course, Peacekeepers Task Force, but make sure you also connect with the Assembly. The whole point of this is to connect with your home. Stop going elsewhere. U.S. citizens like to go everywhere else but home. Americans, stay home and support home. All right, so we have a new national this week, Jason on Howard County. We want to welcome him. Woohoo! Welcome home, welcome home, welcome home. All right, now so I've got the date up here. I haven't updated the numbers here because I was going to do that last night, and the LRO was under maintenance last night. So I figured, well, I'm probably not going to be able to get much, not to do that right now. So hopefully I'll have that again updated to give some updated numbers in through here. All right, reminder to make sure that you're signed up with the email list so that you can receive all the information. It's not just about when the assembly calls, but it's also actual there's information for you to learn, education through there as well. You wanted information where it was more aligned and organized so that you can get it, so it saves you some time. Well, but you have to read the emails. You have to get it and then still actually do it. Okay? So I still can't put it in your head for you. So, but you have to get the email so that you can be able to get that information. Because remember, while you're seeing yourself as maybe being the only one around, we've got over 500 already that I'm trying to maintain communications with. Okay. So I'm not able to always do that one-on-one and send you a separate email just because you weren't able to go in and read the same email that was sent out that has the information. So you still have to look at it. All right. And you have to make sure you have an LRO member record so that we're keeping the countrywide database of those that are nationals and citizens. Even if you don't publish your documents, have your documents published there, you can. We still have to have an account for you. All right. So let's go ahead and jump into this. Let me stop sharing here. Drop this down. I want to keep those. So now let's see. This still needs to be free conference call. And I need free conference call is now where I have the audio recording set up. Okay. Before I start that. All right. We've got John on Carroll County. Welcome. He is on YouTube. Welcome, dear. Thank you. Happy day after Mother's Day, both of you. Everybody that's on the call, listening to the call, afterwards to the call. Happy after Mother's Day. All right, so we're keeping this short and sweet because it is my husband and I's 29th wedding anniversary. So for our first marriage, we ended up getting married. We renewed our vows a second time because of the space in the last name, but that's a whole other story. So keeping it short and sweet. And as I had said earlier, I'm not sure, John, if you were able to catch it. Free conference call gives the link right away. So I'll be able to put the presentation and the link right up on the Assembly website right after the call. The indianaassembly.org assembly calls. Okay. So that way you can be able to go back if there was anything that you missed, because I'm running quickly through this so we can do this. All right. So let's go ahead and get this reading in and we'll get going.
Greetings, this is Christine Van Pelt on Gibson County, State Coordinator for the Indiana Assembly, and we are continuing with the reading of Ex parte Milligan, and we are starting on page 8 on the side of the United States. 1. Jurisdiction. 1. As to the jurisdiction of the Circuit Court, the record shows that the application was made to the court in open session. The language of the third section contemplates that it shall be made to a judge. But independently of this, the record does not state the facts necessary to bring the case within the Act of 1863. It does not show under which section of the Act it is presented, nor allege that the petitioners are state or political prisoners otherwise than as prisoners of war, nor that a list has been brought in or that it has not been brought in. If a list has been brought in and containing the name of one of these petitioners, it would have been the judge's duty to inquire into his imprisonment. If no list had been brought in, his case could only be brought before the court by some petition, and the judge, upon being satisfied that the allegations of the petition were true, would discharge him. But there is no certificate in the division of opinion that the judges were or were not satisfied that the allegations of these petitioners were true, nor were the petitions brought under the division provisions of that duty. But conceding for argument's sake this point, a graver question exists. 2. as to the jurisdiction of this court. If there is any jurisdiction over the case here, it must arise under the acts of Congress, which give to this court jurisdiction to take cognizance of questions arising in cases pending in a circuit court of the United States and certified to the court for its decision, and then to be remanded to the circuit court. This appellate jurisdiction and is defined and limited by the single section of the Act of 1829, or of April 29, 1802. The case is not within the provisions of this section. First, the question in the court below arose upon the application for a habeas corpus. Before there was a service upon the parties having the petitioner in custody, before an answer was made by those parties, before the writ was ordered or issued, while yet there was no other party before the court except the petitioner. The case was then an ex parte case and is so still. The proceeding had not yet ripened into a cause. No division of opinion in such a case is within the purview of this section. The division of opinion on which this court can act must occur in the progress of a case where the parties on both sides are before the court or have a status in the case. The right to send the question or point of division to this court can only arise upon the motion of the parties or either of them, not by the court on its own motion for its own convenience. The record hardly exhibits the Attorney of the United States, Mr. Hanna, as taking any part. The parties have an equal right to be heard upon the question in the court below. It must appear to them in open court that the judges are divided in opinion. They must have an equal right to move for its transfer to this court. They must have an equal opportunity to follow it here, argue it here, as volunteers, not as amateur, not by permission, but as parties on the record with equal rights. This record shows no parties except the petitioner. Its title is Ex parte Milligan. The persons who are charged in the petition as having him in wrongful custody are not made parties and had, when the question arose, no right to be heard as parties in the court below and have no right to be heard as parties in this court. In such a case, this court cannot answer any one of the questions sent here, especially the one, had the military commission jurisdiction to try and condemn Milligan. For if the court answered that question in the negative, its answer is a final decision, and as it is asserted, settles it for all the future of the case below. And when hereafter that case shall in its progress bring the parties complained of before the court, silences all argument upon the vital point so decided. What becomes of the whole argument which will be made on the other side of the right of every man before being condemned of crime to be heard and tried by an impartial jury? Second, this is being an ex parte application for a writ of habeas corpus made to a court. The division of opinion then occurring was in effect a decision of the case. And it was referring to at the asterisk United States v. Daniel, 6 Wheaton, 542, Davis v. Braid, 10 Peters, 289. The case was ended when the court declined to issue the writ. It was not a division of opinion occurring in the progress of a case or the trial of a case. And when it was announced to the petitioner that one judge was in favor of granting the writ and that the other would not grant it, that settled and ended the case. The case had not arisen within the meaning of the statute, when from necessity the case and the progress of the case must stop until the question should be decided. And as Milligan was sentenced to be hanged on 19th May, for aught that appears, we are discussing a question relating to the liberty of a dead man. Having been sentenced to be hanged on the 19th, the presumption is that he was hanged on that day. Any answer to the question raised will therefore be answers to moot points, answers which courts will not give. And that reference is 6 Wheaton, 548, 10 Peters, 290. Third, if the parties had all been before the court below in the case in progress, and then the questions certified, the parties were now here, the court would not answer these questions. 1, every question involves matters of fact not stated in the agreed case or admitted on demurrer, but alleged by one of the parties and standing alone on his ex parte statement. That reference is Wilson v. Barnum, 8 Howard, 262. Number 2, all of the facts bearing on the questions are not set forth, so that even if the parties had made an agreed state of facts, yet if this court find that other facts important to be known before a decision of the question do not appear, the questions will not be answered. That reference is United States versus Citibank of Columbus, 19 Idaho 385. Not sure what the ID stands for. Number 3, the main question certified the one as the counsel for the petitioners assert, on which the other two depend, had not yet arisen for decision, especially for final decision, so that if the parties had both concurred in sending that question here, this court could not decide it. If it be said this question did arise upon the application for the writ, it did not then arise for final decision, but only as showing probable cause, leaving it open and undecided until the answer should be made to the writ. A case upon application for the writ of habeas corpus has no status as a case until the service of the writ on the party having the petitioner in custody and his return and the production of the body of the petitioner. No issue arises until there is a return. And when that is made, the issue arises upon it. And in the courts of the United States, it is conclusive as to the facts contained in the return. That reference is Commonwealth v. Chandler, the 11 Massachusetts 83. Number 4, the uniform practice in this court is against its jurisdiction in such a case as this upon ex parte proceedings. All the cases, some 20 in number, before this court on certificates of division during all the time that this jurisdiction has existed are cases between parties and stated in the usual formula of A, B, B, or B ad sanctum A. So to all the rules of this court as to the rights and duties of parties in cases before this court exclude the idea of an ex parte case under the head of appellate jurisdiction. Number 2, the merits or main question. Mr. Speed, AG, and Mr. Butler, by the settled practice of the courts of the United States upon application for a writ of habeas corpus, if it appear upon the facts stated by the petitioner, all of which shall be taken to be true, that he could not be discharged upon a return of the writ, then no writ will be issued. Therefore, the question resolves themselves into 2. 1, had the military commission jurisdiction to hear and determine the case submitted to it? And 2, the jurisdiction failing, had the military authorities of the United States a right at the time of filing the petition to detain the petitioner in custody as a military prisoner or for trial before a civil court? So number 1, a military commission derives its powers and authority wholly from martial law. And by that law and by military authority only are its proceedings to be judged or reviewed, and that's referencing Dines v. Hoover, 20 Howard 78, and ex parte Vallandigham, 1 Wallace 243. Number 2, martial law is the will of the commanding officer of an armed force or of a geographical military department expressed in time of war within the limits of his military jurisdiction. As necessity demands and prudence dictates, restrained or enlarged by the orders of his military chief or supreme executive ruler.
And that's referenced by Hansard's Parliamentary Debates, 3D Series, Volume 95, page 80, Speech of the Duke of Wellington, Opinions of Attorneys General, Volume 8, page 367. Number 3, military law is the rules and regulations made by the legislative power of the state for the government of its land and naval forces. That references Kent's Commentaries, Volume 1, page 341, Note A. Number 4, the laws of war, when this expression is not used as a generic term, are the laws which govern the conduct of belligerents towards each other and other nations. Flagranti bello. These several kinds of laws should not be confounded, as their adjudications are referable to distinct and different tribunals. Infractions of the law of war can only be punished or remedied by retaliation, negotiation, or an appeal to the opinion of the nations. Offenses against military laws are determined by tribunals established in the acts of the legislature which create these laws, such as courts martial and courts of inquiry. The officer executing martial law is at the same time supreme legislator, supreme judge, and supreme executive. As necessity makes his will the law, he only can define and declare it, and whether or not it is infringed and of the extent of the infraction he alone can judge, and his sole order punishes or acquits the alleged offender. But the necessities and effects of warlike operations which create the law also give power incidental to its execution. It would be impossible for the commanding general of an army to investigate each fact which might be supposed to interfere with his movements, endanger his safety, aid his enemy, or bring disorder and crime into the community under his charge. He therefore must commit to his officers, and in practice to a board of officers as a tribunal, by whatever name it may be called, the charge of examining the circumstances and reporting the facts in each particular case, and of advising him as to its disposition. The whole matter to be then determined and executed by his order. And that references examination of Major Andre before Board of Officers, Colonial Pamphlets, Volume 18. Hence arise military commissions to investigate and determine not offenses against military law by soldiers and sailors, not breaches of the common laws of war by belligerents, but the quality of the acts which are the proper subject of restraint by martial law. Martial law and its tribunals have thus come to be recognized in the military operations of all civilized warfare. Washington in the Revolutionary War had repeated recourse to military commissions. General Scott resorted to them as instruments in which to govern the people of Mexico within his lines. They are familiarly recognized in express terms by the Acts of Congress of July 17, 1862, Chapter 201, Section 5, March 18, 1863, Chapter 75, Section 36, Resolution number 18, March 11, 1862, and the jurisdiction over certain offenses is also recognized by these acts. But as has been seen, military commissions do not thus derive their authority, neither is their jurisdiction confined to the classes of offenses therein enumerated. Assuming the jurisdiction where military operations are being in fact carried on over classes of military offenses, Congress, by this legislation, from considerations of public safety, has endeavored to extend the sphere of that jurisdiction over certain offenders who were beyond what might be supposed to be the limit of actual military occupation. As the war progressed, being a civil war, not unlikely as the facts in this record abundantly show, to break out in any portion of the Union in any form of insurrection, the President, as Commander-in-Chief, by his proclamation of September 24, 1862, ordered, quote, that during the existing insurrection and as a necessary means for suppressing the same, all rebels and insurgents, their aiders and abettors within the United States, and all persons discouraging volunteer enlistments, resisting militia drafts, or guilty of any disloyal practice, affording aid and comfort to rebels against the authority of the United States shall be subject to martial law and liable to trial and punishment by courts, martial, or military commission. Quote, second, that the writ of habeas corpus is suspended in respect to all persons arrested or who now or hereafter during the rebellion shall be imprisoned in any fort, camp, arsenal, military prison, or other place of confinement by any military authority or by the sentence of any court-martial or military commission. This was an exercise of his sovereignty in carrying on a war which is vested by the Constitution and the President. And that references Brown v. the United States, 8 Branch 153. This proclamation, which by its terms was to continue during the then existing insurrection, was in full force during the pendency of the proceedings complained of at the time of the filing of this petition and is still unrevoked. While we do not admit that any legislation of Congress was needed to sustain this proclamation of the President, it being clearly within his power as Commander-in-Chief to issue it, yet if it is asserted that legislative action is necessary to give validity to it, Congress has seen fit to expressly ratify the proclamation by the act of March 3rd, 1863, by declaring that the President, whenever in his judgment the public safety may require it, is authorized to suspend the writ of habeas corpus in any case throughout the United States and in any part thereof. The offenses for which the petitioner or for the purpose of this hearing is confessed to be guilty are the offenses enumerated in this proclamation. The prison in which he is confined is a, quote, military prison, end quote, therein mentioned. As to him, this acts and imprisonment, the writ of habeas corpus is expressly suspended, apparently admitting by his petition that a military commission might have jurisdiction in certain cases. The petitioner seeks to accept himself by alleging that he is a citizen of Indiana and has never been in the naval or military service of the United States, or since the commencement of the rebellion, a resident of a rebel state, and that therefore it had been out of his power to have acquired belligerent rights and to have placed himself in such a relation to the government as to enable him to violate the laws of war. But neither resident nor propinquity to the field of actual hostilities is the test to determine who is or who's not subject to martial law, even in a time of foreign war, and certainly not in a time of civil insurrection. The Commander-in-Chief has full power to make an effectual use of his forces. He must therefore have power to arrest and punish one who arms men to join the enemy in the field against him, one who holds correspondence with that enemy, one who is an officer of an armed force organized to oppose him, one who is preparing to seize arsenals and release prisoners of war taken in battle and confined within his military lines. These crimes of the petitioner were committed within the state of Indiana, where his arrest, trial, and imprisonment took place, within a military district of a geographical military department duly established by the Commander-in-Chief within the military lines of the Army and upon the theater of military operations, in a state which had been and was then threatened with invasion, having arsenals which the petitioner plotted to seize, and prisoners of war whom he plotted to liberate, where citizens were liable to be made soldiers and were actually ordered into the ranks, and to prevent those becoming soldiers, the petitioner conspired with and armed others. Thus far, the discussion has proceeded without reference to the effect of the Constitution upon war-making powers, duties, and rights, save to that provision which makes the President Commander-in-Chief of the armies and navies. Does the Constitution provide restraint upon the exercise of this power? So we'll go ahead and end here and pick back up next week's call. Thank you. Have a great day.
All right. So that was the, let me screen share again. That was the reading for this week on Ex parte Milligan. We should still, we're not screen sharing there. Why are we not screen sharing here? The conference call. Oh, I wonder if that shared all that. Oh, no. Okay. This, I don't know what is going on with it. I wonder if we're still in the tails of Mercury retrograde, but okay. So you're seeing there. So let me screen. It's saying it's screen sharing here, but it's not. Let's go back to here. But it wasn't. I am not sure what is going on with all this. Okay, so we'll see if we can get this again. We'll just go to here for this. Because that should, I'm not sure if it's, no, it's not really screen sharing there either. I'm not sure what's going on. It's telling me it's screen sharing, but it's not. So anyway, that's probably a good point to go ahead and let me get, yeah, because everything seems to be going all crazy. Let's see if it does it now with the camera. Well, it's saying it's still screen sharing, but that's not what it was screen sharing. Not sure, because this should be screen sharing pre-conference call, but it's not. Okay, so anyway, I'm not sure really what's recording where other than hopefully sound is still being recorded. So we'll go ahead and end the call here as a reminder again that the next assembly calls, which in the presentation I have the Anna's updated list of articles. All right, so May 20th for General Assembly, May 27th for Jural Assembly, both at 6 p.m. Central. So I want to wish you all peace and love and have a great night. Take care.
Goodbye.